Hi, good afternoon if you are on the East Coast, and good morning if you're out west. This is Aaron Lacey. You're listening to Decoding the Final Borrower Defense Rule, which is a webinar series being brought to you by the Thompson-Coburn Higher Education team. Today we are going to be covering the third in our four-part webinar series, and we're going to be talking about changes to the closed school and false certification discharge provisions. I really appreciate folks tuning in. You know, when we sort of decided what we were going to talk about, I had a concern that many would see this topic and think, well, my school's not closing and we don't falsify FAFSAs, so why would I listen in? But I think you'll find today that there are some provisions here that are trickier and a little more interesting and maybe surprising and have application for a lot of institutions. My name, I should say again, is Aaron Lacey, if it happens that this is your first webinar with us, and I'm a partner in the higher education practice at Thompson-Coburn. This is a law firm. We are based in St. Louis, but have offices around in other places in the country and have about 400 attorneys, more or less. Our higher education practice, or at least the part that I'm really most involved in, is sort of the regulatory practice, and we focus our efforts in three different areas. We provide regulatory counsel on federal, state, and accrediting agency laws and standards, so this webinar series would fall very much into that bucket. We assist with post-secondary transactions, contract drafting and negotiation, policy creation, and compliance systems design. So we help schools with all different kinds of arrangements and policies and investigations, things all along those lines. And then finally, we will represent folks in both student and employee litigation, government investigations, and administrative proceedings. So program reviews with the Department of Education, for example, things along those lines, or withdrawal action from an accreditor. Before I was with Thompson-Coburn, I spent 4 years in-house at a post-secondary institution, so I am very familiar with what it's like to be on the other end of the line. And prior to that, spent about 8 years with a law firm in Washington, D.C., again, in the higher education practice. Here's the outline for today. We're going to start with politics and prognostications. And we'll talk about the new rule at 40,000 feet. If you've been listening in throughout this series, you've heard some of this conversation before, but we'll quickly get to what I call a CSD, or Closed School Discharge Primer. Then we'll do changes to the CSD Framework. I want to really focus on some of the selected commentary today. Part of what drew me to this topic was some of the discussion in the preamble and some of the positions that the department laid out there that you may not see elsewhere. It is true that reading the preambles to these final regulations is slow and tedious work, but the fact of it is there's often a lot of very interesting discussion in those documents that's very relevant to what a lot of schools are doing or thinking about doing. We'll move on to false certification discharge there at the end. And then finally, as always, we have some resources for you all. Politics and prognostication. So the million-dollar question, and again, those who've listened in have heard me say this before, but this, you know, will this rule go into effect? And I think that it's as likely it will not as it will. I think certainly there is a chance that it will be either killed or changed in the coming days. The first question is whether there would be a Congressional Review Act type piece of legislation that would have an impact. So in 1996, Congress passed the Congressional Review Act, and it basically permits Congress to enact what's called a resolution of disapproval, and that has to be passed by both houses of Congress and signed by the President. But what it enables Congress to do is to kill regulations that have been reported to Congress within a certain time frame. They have to act within 60 legislative days of the rule's introduction, and that means being reported to Congress. So that's a little different from the day it was put into the Federal Register. The salient point here is legislative days are very different than calendar days. So, for example, in 2016, because it was an election year, there really weren't that many legislative days on the calendar. The Congressional Review Service, CRS, has done some analysis, and they think it's possible that rules that were reported to Congress as far back as last May 30 could still be potentially subject to a Congressional Review Act type action. So you're talking about a lot of rulemaking, and certainly including this rule, which wasn't even included in the Federal Register until November 1st. The nice thing about the CRA, at least if you're trying to use it, is that it sets an expedited legislative path, so it makes it a lot easier to get through. It only requires a simple majority and it's more or less filibuster-proof. So that's quite significant if right now you're the Republicans, for example, and you're targeting some of these rules and thinking about what it would take. Another really interesting thing about the CRA is if Congress acts pursuant to the CRA to kill a regulation, the agency is also barred from introducing a substantially similar regulation in the future. So it's a pretty significant way to go about killing a rule. But there are a couple other options too. Another would be removal through rulemaking. So that would still require many months, but the department could essentially start a new process to reevaluate this rule, and through that process strip out a lot of it or kill it completely. And the department, at the direction presumably of the White House, could also suspend enforcement of all or certain portions of this rule. So there are a lot of different things that could happen. You know, so why should you pay attention? Well, first of all, Congress isn't going to act, nor will the White House for that matter, if bar defense is not a priority. I think it is a priority. I think it is on the radar of Senator Alexander, you know, who's head of the Help Committee over in the Senate, Congresswoman Fox, who's going to be heading up the Education Committee in the House. But the fact is they have a lot of things to think about. I've been in various conversations with different types of attorneys in different industries, and they are all looking at types of rules that could be affected or possibly included in a CRA action. So there's a lot on the plate of the folks in Washington, and it's really important to keep in mind that as important as this is to us, the only way this happens is if somebody in Congress actually is noticing. The borrower defense statute and the existing rule are already on the books and will remain even if the new rule is struck down. Well, what do I mean by that? So remember, there is already a borrower defense statute and regulation, and you've already had 10,000 plus, many thousands of borrower defense applications that have been filed. Even if this new rule gets killed, that's still going to be out there, and you're still going to have folks at the department who are going to have to figure out how to manage that and how to adjudicate these claims. And those folks are some of the folks who've been involved in this process. And so what you're seeing here tells you a little bit about what they may think and how they may go about managing some of these things. And certainly when you're talking about financial responsibility and closed school and false certification discharge, these are also things that already exist. So even if this new rule specifically gets killed, understanding this rule is important because it may give you signals as to how some of these things are going to be handled in the future. All right, so from 40,000 feet, as many of you know, this is a very complicated rulemaking, meaning there are a lot of different pieces to it. In our prior couple of sessions, we talked about the borrower defense piece, which is the headliner, and we've also talked about financial responsibility triggers. Today, we're on the discharges, closed school, and false certification, and on Thursday, we'll talk about arbitration agreements and repayment rates. And we discussed misrepresentation in the context of our first session on borrower defense. This is the implementation timeline. As you know, earlier this year they had the negotiated rulemaking sessions. June 16, the proposed rules were published. In August, the comment period closed, and November 1 is when we saw the final rules promulgated. They are set to go into effect July 1, 2017, although as we will discuss today, and you see it's the second little footnote down here, the department has designated certain portions of this rulemaking for early implementation, and that actually includes some of the rules we're going to discuss. So let's talk about closed school discharge. Okay, the CSD Primer. It's important to know a few things about closed school discharge before we actually talk about what's being changed. And I think that some folks may be surprised. I often have conversations with clients or just folks in the industry about what closed school discharge is really all about. And there's not always a lot of clear understanding about certain important aspects of the current framework. So first of all, when is a borrower eligible for a CSD? If a borrower is unable to complete the program, that's really an important concept, unable to complete the program, we'll come back to it, in which he or she enrolled due to the closure of the institution, then the department shall discharge the borrower's liability on the loan, and that includes interest and collection fees, by repaying the amount owed on the loan. That's in current law. Again, all of this is current law. Why should a school be concerned with CSD exposure? Because the HEA, and that is the statute, not the regs, specifies that the department shall, so it's not an option, shall subsequently pursue any claim available to such borrower against the institution and its affiliates and principals, or settle the loan obligation pursuant to its financial responsibility authority. So 2 important concepts here. The first is, if you have a student, if you have a school closure, right, and you have a group of students who, as a result of the closure, are eligible for a closed school loan discharge, and those amounts are discharged, then the HEA, this isn't in regulation, this is in statute, Congress has directed the department and placed upon it an obligation to pursue those amounts, to try to recover those amounts. And it's also important to know that the obligation the department has is not only to pursue those amounts against the school, but also its affiliates and principals. So this is a broader concept even than some of the language you've seen in the proposed borrower defense regs. And this is in existing law, right? There is not a definition of affiliates and principals that's in this specific section of the HEA, but there are definitions of affiliates and principals that are floating around in other parts of the law and regulation that the department enforces, and certainly in other places within federal government. And I will just tell you, typically affiliate and principal are pretty broad concepts. Principal can include, for example, senior management, owners, potentially, or board and directors. So there is some exposure here for a lot of people that could be involved in the institution. The department can recover from the school the amounts forgiven through CSD, so I made that a question mark. Yes. So again, the HEA specifically provides that a borrower whose loan has been forgiven has been deemed to have assigned to the United States the right to a loan refund up to the amount discharged against the institution and its affiliates and principals. And this is important. This statutory concept, I will note, does not exist with regard to borrower defense. And that's one question that has been raised, is whether the department really has the statutory authority, if it forgives loans in the context of borrower defense proceeding, to then turn around and try to recover from the institution. And there are obviously the arguments the department would make and arguments others would make. But in the case of closed school loan discharge, it seems pretty clear. The statute expressly provides the department with that right, or creates that right for the department. This right has been challenged and it has been affirmed. So this is an excerpt from an OHA decision. The applicable federal statutes, regulations, and case law specify that upon closure of a school, the Secretary has the authority to discharge students' loans if they're unable to complete their academic program due to the school's closure, and then recover the value of the discharged loans from the institution. And you can see there's a string cite here, but this isn't something that's just come up once. It's come up multiple times and has been affirmed. So are parents who took out PLUS loans, are they able to file for a closed school discharge? Yes. So both the statute and the regulation make clear that a parent borrower is eligible to apply for a CSD if the student on whose behalf a parent borrowed is unable to complete the program due to closure. So this also extends to all those PLUS loans that may have been taken out for folks who were enrolled and then eligible for a CSD. So this is a really important point. Does the CSD framework only apply to the closure of the main campus and its locations? No. No. So for purposes of the closed school discharge framework, a school means a school's main campus or any location or branch of the main campus, regardless of whether the school or its location or its branch is considered eligible. So this is one reason I mentioned at the top, you know, when people see closed school loan discharge, traditional institutions, I think frequently large nonprofits or state institutions think, well, our school's not closing, this doesn't apply to us. But a lot of schools out there, including many traditional institutions, if you pull up their e-car, you're going to see a laundry list of additional locations. They've established sites, extension centers, satellite locations, sites on military installations, locations around the world. And the salient point here is that every time you close one of those locations, you have a potential closed school loan discharge liability, right? Every single time. So all those traditional institutions out there that have many, many additional locations, these regulations apply to them and this exposure exists for them, and that's why the changes proposed by this rule are relevant. When is a school considered closed? Another great question. So the department considers a school closed as of the date that the school ceases to provide educational instruction in all programs. Sometimes, and I've been involved over the years in helping schools that are winding down or closing, and sometimes they'll say, well, you know, we're going to have our last classes as of date X, the end of the term, but we're going to stay open for 2 months, and, we'll have our career services staff, or we'll have, other folks, faculty available, et cetera, to help folks transition, to find their way to another school, transfer credits, et cetera, et cetera. So they may not actually close the doors for 2 or 3 months after their last day of classes, but the department will consider the school closed as of the date that the school ceases to provide instruction in all programs. And they'll specifically ask you that. So if you ever report to the department that you are taking a location off of your e-car, for example, and they understand that to mean that location is no longer going to be around, they're going to ask you, well, when did you start offering or cease offering instruction at that location? So exactly which students are eligible for a closed school loan discharge? This is another point that sometimes is missed. So the regulations extend eligibility to any student who could not complete his or her program because the school closed, or who withdrew from the school not more than 120 days prior to the date the school closed. Okay, so now you're not just talking about folks who were enrolled, right, but up to 4 months prior to that last day you offered instruction. Anyone who was enrolled and withdrew during that period could also be eligible for a closed school loan discharge, right? The other thing to note is that the regs make clear the department may also extend the 120-day period in exceptional circumstances, which includes the school's loss of accreditation, the school's discontinuation of the majority of its academic programs. So look, and remember, school can mean location. So if you've got an additional location somewhere, an extension site, and you're going to close it down completely, then that's the discontinuation of the majority of the academic programs at that location, right? And the department could, in that circumstance, at least they claim under the regulation, the authority to extend eligibility for a closed school loan discharge back more than even 4 months. 2 other items that are included: action by the state to revoke the school's license to operate, or a finding by a state or federal government agency that the school violated state or federal law. What if we arrange for a teach-out or transfer opportunity? This is another point where there is often some confusion. A student remains eligible for a closed school loan discharge so long as he or she has not completed the program through a teach-out or transfer opportunity. So what that means is, to be clear, you could make arrangements for teach-outs and transfers. Let's say you have 200 students that are going to be enrolled at the time you close, and you manage to get all 200 of those students into a teach-out or transfer opportunity. They are all interested, they take advantage of the opportunity, and it's a great opportunity for them. And they are, after that point, in the other school. You close, and they are off getting their education. If they determine not to continue, so let's say they get a month or 2 into the teach-out, or they transfer to the other school, and it turns out it's too far for them to commute, or they don't like it, and then they stop, they're eligible for a closed school loan discharge. Right? So you may think that you have significantly mitigated your exposure because you've arranged for a teach-out or transfer opportunity. And that may be true. As we note at the end, I mean, there's no doubt that arranging teach-out and transfer opportunities is helpful, but it does not necessarily mitigate CSD exposure. In fact, I mean, at least in theory, you could put together a teach-out opportunity or a transfer opportunity, and every one of your students could reject it and file for a closed school loan discharge, provided they were enrolled at the time you ceased offering instruction and or they withdrew 120 days. They were enrolled in but withdrew 120 days of that last date of instruction. All right, so this is what the current CSD cycle looks like in terms of sort of procedurally how it works. Upon confirming a school closure, the department attempts to identify and provide CSD information to all eligible borrowers. So there is a regulatory directive that the department is supposed to identify who is eligible and send them information about closed school loan discharge. As a practical matter, historically, I will tell you, that has not always happened. And schools, historically, have not been obligated to provide information about closed school loan discharge at the time that the school closes, with the result that many students often were unaware or unclear as to their closed school loan discharge opportunity. And that's not me pointing the finger and saying anybody did something right or did something wrong. I will tell you, as a guy who works with closures, they are messy business, and it is never neat and easy. Students start to leave as soon as you announce a closure, even if it's just an additional location or extension site. Once you announce that site is closing down, a lot of different things can happen, and it can be very hard to efficiently communicate information to everybody who's affected. And this is particularly the case if you're talking about folks who've withdrawn and aren't even at the school anymore, right? So that's not me pointing the finger, but the fact is the communication to borrowers in the past has not been that efficient. The department, one of the main objectives of this rulemaking, and also just administratively over the last 2 years, they have been working much harder to get these lists and to communicate to students their closed school discharge opportunity. Borrowers still have to submit a written request or sworn statement to the holders of the loan for the discharge. Now, there are a couple of situations where the department can initiate a discharge, and actually that's something in the new rules they're proposing to augment. But for the most part, historically, if a borrower did not file for a closed school loan discharge, they weren't going to get one. Under penalty of perjury, that is quite clear in the current law, a borrower must state the claim and their qualifications. So, you know, they have to prove that they're eligible, that the school actually closed, that they were enrolled at the appropriate time, et cetera. The borrower has to agree to cooperate with the department and to provide evidence and testimony as required. Assuming all that happens, the department then determines whether or not to discharge the loans. And if it does, then the department would initiate a separate action to recover discharged amounts from the institution. And we'll talk about it a little bit later, but the way that happens and has been happening most recently is the department will actually initiate either in connection with a closeout audit. So when institutions close, if the entire institution closes, you have to perform an what's called a Title IV closeout audit. Or the department can also do it for program review process. So they'll actually initiate a program review specifically for dealing with the question of borrowers who are eligible for loan discharge and assessing the amounts that they believe are owed to the department. What that means, I mean, the sort of silver lining there for institutions, though, is that if it's done through the auditor program review process, then that means you have the procedural opportunity then, once the department comes to some conclusion as to what they think you owe, to dialogue with them first, and then if you can't reach resolution, to potentially take it to the Office of Hearing and Appeals. And that's why we have decisions on this topic that have come out of the Office of Hearing and Appeals, because they've dealt with these matters that have come before them on the question of closed school discharge. So let's talk about the changes the department is proposing to this framework. There are sort of three. First of all, the new rules, I said that the department's proposing, I apologize. Let's talk about the changes that the department has promulgated to this framework. The first is increased outreach by the department, lenders, and guarantee agencies. The second is increased outreach by institutions. And the third is the concept of an automatic discharge. All right, what kind of increased outreach are we talking about with regard to the department? So if a borrower fails to submit a closed school loan discharge application within 60 days, which is the current required amount, the department or a lender, if it was an FFE loan, would provide the borrower with another discharge application and an explanation of the requirements and procedures for obtaining a discharge. So part of what the department's doing is they're sort of doubling down on their efforts to make sure that its students, or borrowers rather, who've been affected have the opportunity to at least know about and file a closed school loan discharge application. So they're increasing the number of times that they'll be providing information. In addition, if a guarantee agency denies a borrower's closed school discharge, it has to notify the borrower of the reasons for the denial, which seems, frankly, perfectly suitable. It's surprising that that was not already a requirement. So what do institutions have to do for their part? And this was a point of contention. So now, under the new rule, institutions must provide all enrolled students with a closed school discharge application and a written disclosure describing the benefits and consequence of a closed school discharge as an alternative to completing their educational program through a teach-out agreement, right? So the department is specifically contemplating here, to be clear, that an institution may have a teach-out arrangement in place or providing a teach-out arrangement, and they may be providing opportunities or information for folks who want to transfer their credits to another school where they can complete their program. And what the department is saying is it's no longer optional. You have to provide all enrolled students with information about their closed school discharge opportunity, right? Even if you've got a teach-out and how that opportunity stacks up against the teach-out opportunity. When must these disclosures be made? They have to be made immediately upon the institution submitting a required teach-out plan to its accreditor, The provision of the, and this is a quote from the Federal Register, the commentary, the provision of the teach-out plan itself to the accreditor triggers the provision of the closed school disclosures and the application form. Okay, so what specific events trigger a teach-out plan and the distribution of the materials? The initiation by the Secretary of an action under Subpart G, that's to terminate the participation of an institution. I should be clear that there are other things that the department could initiate under Subpart G, which could include a suspension or a limitation, but they've been specific here, interestingly enough, that this triggering event is only if they initiate an action to terminate the participation of an institution. The institution's accrediting agency acts to withdraw, terminate, or suspend the accreditation or pre-accreditation of the institution. And these, I will say, both seem very reasonable to me, right? I mean, if the department's acting to terminate you, or your accrediting agency is acting to withdraw or terminate you, even if you have not announced a closure, it would seem there is a very high likelihood that a closure, if not imminent, could occur. And so these would seem appropriate triggers to start informing students about potential closed school discharge opportunities. But these items cause me more concern. So the institution, state, licensing, or authorizing agency revoking the institution's license or legal authorization to provide an educational program. All right, so let's talk about that for a minute. This is what's interesting to me. So let's say you've got an additional location. You're a large private nonprofit institution, right? And you have sites all around the country or all around the world. And for some reason, a licensing or authorizing agency decides to revoke your authorization to provide a single program at one of those locations, right? And you may offer 25 programs at that location. Interestingly enough, under the law, that triggers a responsibility to provide a teach-out plan, presumably for that one program, to the accreditor, but that would now trigger a closed school loan discharge disclosure to the students, which seems to me incongruous, because in this case you're talking about a single program, not necessarily the entire location, much less the entire school. So I've got one location in Boise where I'm no longer going to be able to offer my, program X, and now I've got to give all those students a closed school discharge disclosure, even though the school's not closing and the location's not closing, and as a consequence, they're not eligible for a closed school loan discharge. At least the way I read the law, they wouldn't be. So, I think it is interesting to me that the department, I'm going to talk about this more in the next 2 or 3 slides, but they created a mechanism that in my mind is pretty blunt without going into some additional detail, which I think could have avoided situations like this. So the second one is the institution intends to close a location that provides 100% of at least one program. So here again, you have a situation where this could be an additional location, and now you've got to make a closed school loan discharge. But the other thing is it doesn't draw any distinction between an institution intentionally and for potentially very good reasons winding down a location in an orderly way. So this isn't necessarily a precipitous closure, right? I mean, maybe institution X, again, a large private or public institution with an additional location decides, enrollments are down or the market's changed or for whatever reason we won't have that location open anymore. So we're going to close our extension site, right? And now you are required to provide everyone there a closed school discharge application, even if you have said we will keep this site open until everyone has graduated or withdrawn. Right? So we're not going to close it precipitously. Everyone will have a chance to finish their program. The institution otherwise intends to cease operations. So I guess that would mean, if your board had a resolution to cease instruction at your additional location, or there was some other way that you had signified that you had that intent, you would again be required to provide a teach-out plan to your accreditor under the law, probably under your accreditor standards, because they, if they're recognized by the department, have to require a teach-out plan in any of these cases. And that would mean it triggers a closed school discharge disclosure. This seems a very cumbersome way to determine when closed school discharge disclosures should be required, in my mind, because they've used sort of an existing regulatory mechanism and made that their triggering mechanism, and it does not seem to be very neat to me. So what exactly must we disclose? The current closed school loan discharge form provided to borrowers is the department's loan discharge application school closure, which you could Google and find online. The department's indicated in the coming months they're going to revise that form to reflect some of the changes in these regulations. Quote, we do not have plans to develop written closed school discharge disclosure materials for schools to use, although we may develop such materials in the future if warranted. So what's interesting here is there's an expectation you would provide their application, but the packaging that goes with the application, you know, your discussion of options, how this relates to a teach out, those types of things, they're not prescribing at this point. That's going to be left open to institutions. So can the department discharge loans without a CSD application? So yes, and again, under current law, the department may discharge a loan without an application from the borrower if the department determines, based on information in its possession, that the borrower qualifies for closed school loan discharge. But here's the big change. So in the new rule, right, says that with respect to schools that closed on or after November 1st, 2013, the department will, and that's a big change, will discharge the loan without an application from the borrower if the borrower did not subsequently re-enroll in any Title IV eligible institution within a period of 3 years. So to be perfectly clear, here's what the department is going to start doing, right? And this is why they backdated it to November 1, 2013, because they can start doing this effectively November 1, 2016. They're just going to run the numbers. They're going to say, who do we know that closed as of November 1, 2013 running forward? Who were the students involved? Let's look in an SLDS and see if based on our records, right, or our gainful employment records or whatever records we have available relating to enrollment, we can determine whether or not this person re-enrolled. And if the person did not re-enroll in another institution within another 3 years, they are automatically discharging their loans, automatically, right? The department has also indicated that with regard to this specific provision, it intends to pursue early implementation. ED intends to exercise its authority under Section 482 of the HEA to implement the new and amended regulations specific to automatic closed school discharges as soon as operationally possible after the publication date of these final regulations. We will publish a separate Federal Register notice to announce this implementation date. Now, keep in mind, this doesn't necessarily impact every institution that has closed since November 1, 2013 right away, because they still have to be able to determine whether or not the student has re-enrolled within the 3-year time frame. So at the moment, they would only be able to look at students at institutions that closed between November 1, 2013 and December 6, 2013. And to see if their students had re-enrolled in the 3-year time frame. So if you closed in, say, 2015, that 3-year time frame hasn't run yet. So the early implementation, the point I'm making, is not going to necessarily affect you at this point. And if the rule goes away or is significantly augmented or killed by CRA, it may never affect you. But if this provision sticks, what that means is on a going forward basis, presumably the department will, at some regular interval, simply run the numbers. And anyone who hasn't re-enrolled within 3 years of a school closure will automatically get their loans discharged. And remember, under the statute, the department shall pursue those amounts outstanding against the institution, right? And its affiliates and its principals. What is unclear to me is how the department plans to use the program review mechanism or the audit mechanism to figure out the amounts owed that have been automatically discharged, right? Because right now, I mentioned earlier, if you have a school closure, typically what the department does is within a few months of the closure, they initiate a program review, or the closeout audit has to happen within so many days of the closure itself. So the information regarding the closure, the school, it's, you know, the staff, their whereabouts, whoever was administering the financial aid program at the school, those folks are still around and somewhat available. What is interesting to me is, in this scenario, you're talking about the automatic discharge taking place 3 years after the school closed, right? So all of the people who were associated with that school could be long gone at that point. And what's unclear is, so does that mean when the automatic discharge occurs 3 years later, then the department's going to initiate a program review to try to figure out how much the institution they think owes them, or that they automatically are going to discharge? I don't know. It'll be interesting. But what the department has suggested is that even when you have this automatic discharge circumstance, institutions will still have an opportunity to contest it within the framework of the same process that governs audits and program reviews. All right. So some selected commentary regarding the application of the rule to wind downs. So this is a quote from the department. We disagree with the recommendation that a school that plans to keep a closing location open until all of the students have either graduated or withdrawn should be exempted from the requirement to provide its students with the closed school disclosures or the application. Because all students at such a school or location are entitled to the option of a closed school discharge. We believe that all such borrowers should receive this information so that they have full knowledge of their options. While many of the students at such a school or location may plan to take advantage of the teach-out, not all necessarily will. So it's, of course, possible that there were other people who posed this question, but this is certainly one of my comments that I put in to the proposed rule, because I work frequently with institutions that will make a decision. They say, you know what, we're not going to close quickly. In fact, we're not even going to involve a third party to come help teach out our students. We're going to stay open until everyone has graduated or withdrawn, right? And if everyone doesn't withdraw, if they stick around, that means everyone will have the opportunity to complete their program. What the department is saying here is that even in a situation where a school plans to, and in fact stays open until all the students have either graduated and withdrawn, they say all students at such a school or location are entitled to the option of a closed school discharge. I'm not sure. The HEA says if a borrower is unable to complete the program in which he or she enrolled due to the closure of the institution, then the department shall discharge the borrower's liability on the loan. So my question is, if you are willing to stay open, and in fact stay open until everyone has an opportunity to graduate, let's say nobody withdrew, let's say everybody has an opportunity to graduate, no one would be able to file for closed school loan discharge. In fact, they've all completed their program, so no one was unable to complete the program. But I think you could even ask the question, if somebody withdrew, but you had pledged to stay open until everyone had graduated, and let's say the person who withdrew could have graduated in the time frame that you remained open, were they unable to complete due to the closure? It would seem to me as a fact that they were not. That they could have completed despite the closure. So I thought this was really extraordinary when I read this piece of commentary from the department. So what they are saying is, again, and I think this is a salient point, if you are a private nonprofit or a for-profit or a state institution, it doesn't matter. If you've got an additional location somewhere and you say, we're gonna wind down this additional location, we're gonna stay open until all of our students have graduated. What they're saying is anyone who withdraws within the 4-month period prior to you ceasing operations or instruction at that location would be eligible for a closed school loan discharge, without regard to the fact that you remained open long enough for them to actually complete their program. I mean, that's the position that the department has taken, which, again, I thought was extraordinary, and I don't necessarily believe that that's consistent with the law, but it gives you some insight into what they're thinking right now. Regarding the impact of the rule on program completion, we disagree with the comments suggesting that the proposed regulations create an incentive to withdraw that is contrary to public policy. So a lot of people pointed this out. They said, look, you know, if we're setting up a teach-out plan and there are opportunities for them to transfer and we're working very hard to make sure that that happens and we've created these opportunities, aren't we doing a disservice and isn't it acting contrary to public policy if we go and then provide everyone with information regarding closed school loan discharge? Because they're going to take advantage of that, and as a consequence, we are essentially discouraging them to complete their program. We're giving them an option where they can get their money back, take their credits, and not complete, right? And we think this is contrary to public policy, and this could be harmful. Although public policy generally favors higher rates of program completion, it is not always in the individual borrower's best interest to continue a program through graduation. In a remarkable statement, but I think the department makes a fair point here. In a closed school situation, the value of the degree the borrower obtains may be degraded depending on the reasons for the school's closure. And the fact of the matter is, I will add, even a school with the absolute best intentions cannot control its employees once it announces a closure, right? So you could have critical faculty and staff that just say, I'm leaving. And there's nothing you can do about that. You can offer them stay bonuses, things along those lines, but they may not take it, right? With the result that the people who stick around to finish their program, indeed, may not have access to the same instruction and quality of services that they would have before. We do not believe that it is good public policy to require these borrowers to repay that debt if they cannot or choose not to complete the program and are eligible for a closed school discharge. So here's my point, and the reason I put this slide up. I don't disagree with the department. I think this is a complicated concept. And I think they are right to note that in a closure situation, even when you have the best intentions and work very hard at it, there's the possibility that the educational experience could be degraded. On the other hand, I also think it is an incredibly valid observation that if you start providing closed school discharge applications to folks, right, that there are going to be many people who take advantage of that, despite the fact that you may have made a very sound teach-out or transfer opportunity available to those students. And not only do they now not complete their program and get their credential, which we know through default analysis and things like that, we've seen that when folks don't get their credential, often that means that later they are not as successful as folks who do get their credential, right? So that's a harm. But also it means that they just discharged all of their loans, which goes back on the taxpayer, particularly if this department can't recover from the school, despite the fact that there was a viable teach-out or transfer opportunity that was available. So I think this is a complicated public policy question. And my criticism here is not to say that the department is wrong, but to say that this is a complicated question and really requires further analysis and a finer touch, I think. And I'm concerned here, you know, that the pendulum is swinging too much either in one direction or the other. I mean, I will share with you all an anecdote. I was out on the West Coast about 5 months ago and I was actually announcing the closure of an institution. So I was announcing to all the students of the institution that the school was going to be closing. And the announcement itself, I started by, you know, sort of talking through the time frames and everything. And of course, there's this sort of shock and awe that comes with that initial discussion because it was not anticipated, all right? That took about 15 minutes. And then, and by the way, I also, and this is my personal belief that you should always do this, I talked about closed school discharge. I don't think at this point it's worth hiding the ball on that. You know, I think it's out there. The department expects you to tell people about it. Students should know about it. And I think it's good policy. And this was a situation where the school was clearly closing. This wasn't, you know, an additional location or something like that was going to stay open until everyone had graduated. It was the whole school, and it was not a situation where there's going to be, they were going to stay open until everyone had a chance to graduate, right? So closed school discharge, that discussion certainly was appropriate. But here's my point. It took me about 15 minutes to cover the key talking points, and then I opened it up for Q&A. Remember, at the beginning of this conversation, no one at this institution, none of the students knew that the school was about to close. At about the 30-minute mark, I had a student stand up in the entire auditorium and say, okay, help me out here. So from what I understand, if I file for a closed school loan discharge and then I get all my loans forgiven, I still get to keep my credits. So why wouldn't I just get the money back and then after it clears, take my credits and transfer somewhere else and complete my program? This guy had figured it out in less than 30 minutes. And I think it is naive to believe that there won't be people who will take advantage of the system, right? I just think that's naive. So my point is, I think it is a complicated, you do have a real need on the part of people to know about closed school discharge, right? But you also have to be aware that people are going to take advantage of the opportunity to dump their loans. So it's a complicated public policy conversation, and I think it probably, my personal view, is worth more conversation. So regarding the application of the rule to voluntary closures, similarly, we disagree with the recommendation that voluntary school closures be exempted from the requirements. As noted earlier, the teach-out requirements in 34 CFR 668.14 apply where the school is forced to close or voluntarily closes. With regard to schools being discouraged from acting responsibly and voluntarily providing teach-outs, as noted above, closing schools are required to provide teach-outs. A school that declines to provide teach-outs as a result of these final regulations would be in violation of the requirements specified in the school's PPA. So, as an initial matter, I mean, I was someone who commented on this point. I think maybe others did. I fear that the department may potentially have missed the point here. I think what we were trying to highlight was the fact that there could be situations where a school should close, particularly like an additional location or a satellite or something like that, but even an entire school should close because there are good financial or regulatory or other reasons for them to do it. It's the responsible thing to do, and let's just say hypothetically that it is the case. We've got a situation where the responsible thing to do would be to close. Our point was these regulations and the way that they are designed potentially incentivize institutions to avoid closure and to keep the school open or the branch or the satellite open beyond the point at which it should be kept open so as to avoid exposure to closed school loan discharge, right? Or to allow the school to sort of peter out without officially announcing a closure or something like that to try to get around some of these requirements. So we're trying to highlight some of the sort of what I'll call perverse incentives that potentially would be created by the way the rule was proposed. What I thought was interesting is the department in its response said closing schools are required to provide teach-outs. So, you know, it's not as if it's an option. If you're closing, you have to provide a teach-out. As an initial matter, what I'll note is what the law requires is that an institution submit a teach-out plan to its accrediting agency. So first and foremost, we've got a failure to be fine enough with this conversation, right? There's a distinction between a wind down, a teach-out plan, a teach-out, and a teach-out agreement, right? So a wind down, typically, and I try to use this nomenclature, is when you decide to keep the school open until everyone is graduated or withdrawn, all right? A teach-out is when you involve a third party because you're not going to stay open until everyone has a chance to graduate, so you're trying to find someone who will teach the rest of your program for you. A teach-out plan is a document that describes how you intend to go about winding down or teaching out the institution. It doesn't mandate that you do one or the other, right? It's just the written plan that describes what you intend to do. So in theory, I believe you would be satisfying federal law if your teach-out plan was, we're going to stay open for the next 2 weeks, and then we're going to try to set up a transfer opportunity for everybody. That doesn't, so the law doesn't obligate someone to actually teach out the program for a particular period of time or in a particular way, right? And a teach-out agreement, incidentally, is the agreement you would have with that third party if you were going to go through a teach-out process and have them come in. The point I'm trying to make here is that there are a lot of important concepts here that are sort of being glossed over with the way the department has addressed both the regulations and the commentary, right? And it seems a little sloppy to me, and that's problematic because, to be frank, I mean, there are students and schools with interests at stake here, and it's important to be precise. Questions. So why resist these easy distinctions between precipitous closures and an orderly voluntary teach-out and a wind-down? You know, I guess one of my open questions is, would it have been that hard to design the regs in a way that allows the department a mechanism to recognize these distinctions? In fact, again, what's in the regs is you have to provide your accreditor with a teach-out plan. So there ought to be the ability on the part of a regulator to review that teach-out plan and determine which of these buckets you fall into. And then you ought to be able to design requirements relating to disclosure of closed school loan discharge opportunities and things like that based on what's in the teach-out plan. And none of that has really been done here. It's also worth noting that there are regulations that already recognize that some institutions will close without a teach-out plan. So the department already has a reg that says if an institution that an agency accredits or pre-accredits closes without a teach-out plan or agreement, the agency must work with the department and the appropriate state agency, to the extent feasible, to assist students in finding reasonable opportunities to complete their education without additional charges. You know, my thought was, clearly there's a distinction between a precipitous, first of all, as a practical matter, there are going to be schools that are not able to arrange either a teach-out or a wind-down. Right? Why not recognize that? Here, the regulations clearly do recognize that that's a possibility. Secondly, why not come up with a mechanism like review of the teach-out plan that permits you to distinguish between these different types of closures so that you're not putting the precipitous closure of an entire OPID in a main campus in the exact same bucket as someone who is in an orderly fashion closing down an extension site, right? And these regs do not draw any distinction, and that seems to be a failure to me. The other thing I'll point out that's interesting about this last little reg is it also embodies the public policy idea that public policy favors completion of programs, right? Because what this last little reg says is the department and the accreditor will work together to the extent feasible to assist students in finding reasonable opportunities to complete their education without additional charges. So here there is a mandate that the accreditors are supposed to work with the department to find a place for students to complete their education, and that seems to run potentially counter to some of the early sort of discussion and commentary from the department regarding the merit of program completion. I'm sure they would disagree. Regarding due process, particularly in recovery actions against schools. So I covered this earlier. I'll just read this last line, but the department actually in the commentary affirmed that a school may challenge a closed school discharge claim in an appeal under Subpart L of Part 668, as it can with any audit or program review liability. So there were some folks who brought up the fact that now that you've got this automatic discharge and some of these other notions that would seem likely to increase the exposure to schools with closed school discharges, that there ought to for sure be due process. And then what the department is saying is, look, anytime you've got a closed school discharge liability, you will have a due process because you'll have the opportunity to go through what is equivalent to the program review or audit process. So that would give you a chance to get in front of an administrative law judge and even to appeal to the secretary. All right, so let's talk about false certification discharge. This is current false certification discharge framework, so this is what's in the law right now. The department will discharge a borrower's repayment obligation if the school falsely certified the student's ATB status, so that's ability to benefit, signed the student's name on the loan application, certified a student with a disqualifying condition, or certified the student's eligibility as a result of identity theft. This is what the new framework looks like. So we have some of the same old stuff. That first one, you'll see it doesn't say ATB anymore. It says certified that the student satisfies alternative to graduation requirements. So, you know, ATB went away for a while, and then there's a new mechanism that was put in. And instead of referring to ATB, now it's alternative to graduation requirements. More generally, the department updated that language, but it's essentially still the same basis for a false certification discharge. But then we've added the ones that are in orange. They are new. So if you certify the student's status as a high school graduate falsely, if a school falsely certified a student with a disqualifying condition under state law, now this is really similar to what's in current law, but I want to highlight that under state law, and then we're going to talk about this at some length. And then finally, certifies that the students are meeting satisfactory academic progress. Falsely certifies that the students are meeting SAT. So high school diploma, let's talk about each of these. When would a discharge be based on falsifying a diploma? This is the new law. If a school certified the eligibility of a student who is not a high school graduate based on a high school graduation status falsified by the school, or a high school diploma falsified by the school, or a third party to which the school referred the borrower. Now, you know, if schools are falsifying high school graduation status, you know, not only is that obviously a basis for a closed school loan discharge, but, you know, that'll get you sent to prison. Right? So if you're doing that, you shouldn't be doing it. But what jumped out at me was the red, what's in red here, a high school diploma falsified by the school or a third party. So anytime, you know, you're talking about making an institution that I represent potentially liable or increasing its exposure for actions of a third party, that's a flag for me, right, as a risk manager. So what must a borrower establish to qualify for the discharge? Borrowers must certify under penalty of perjury that they reported not having a valid high school diploma or its equivalent at the time the loan was certified. By the way, that was not in the proposed rule. That was something folks commented and said, well, wait a minute, you shouldn't be able to get after a school if there's not something, or the student's not, or the borrower's not willing to go on record saying that they did in fact tell the school they did not have a high school diploma, right? So borrowers have to certify. They have to say, yeah, I told the school I did not have a high school diploma at the time of enrollment, or at the time the loan was certified. And did not satisfy the alternative to graduation from high school eligibility requirements, again, at the time the institution certified the loan. All right, so what can you as an institution do to protect yourself against false claims? First of all, require specific signed disclosures from students prior to admission. And I mean on the fact that they have a high school diploma. So you don't want to rely entirely on you know, if you don't have that, then what you're hoping is that the student will balk at saying, yeah, I told them at the time I enrolled I didn't have a high school diploma. And the fact of the matter is, my expectation is most students who are pursuing this are just going to certify it, right? Either they're telling the truth or they're not. But what you can do as an institution is, if you have an enrollment agreement, then in your enrollment agreement. If you don't have an enrollment agreement, then elsewhere on a freestanding disclosure, you can actually have students certify and sign a statement indicating that they do, in fact, have a high school diploma or its equivalent. And then you put that in their file. Every school that I've ever worked with to design enrollment processes, I mean, this is something that I suggest they do, right? The other thing is strengthen your agreements with any third parties you use to verify diplomas. So my concern, and I'll talk about this more in a minute here, but is that there are institutions that use third parties to verify either that a high school diploma is real or that if it's from a foreign country that it's the equivalent of one in the U.S. And my concern from that prior slide was the department is saying, if that third party you use falsely certify. So if the student behind your back goes to your third party and offers them a bribe to say that their, foreign diploma is in fact a high school diploma, and I should say not the third party, let's just say some guy who works for company X over there, you're on the hook for that. That's what the department is saying under this reg. So my point is, if you have an agreement, some sort of vendor relationship with one of those third parties, I would put in the agreement that you're indemnified if they falsely certify. I mean, that ought to be self-evident, but I would make that really specific in light of this regulation. So regarding institutional liability for third-party actions, I wanted to pull this out of the Federal Register for you all. If a school is relying, and this gives you a sense of how the department feels about this, if a school is relying on a third party to verify the high school graduation status of a borrower, it is incumbent on the school to ensure that the third party is providing legitimate verifications. Any school that wishes to participate in the Title IV programs and outsources the determination of high school graduation status to a third party without ensuring that the third party is trustworthy is acting irresponsibly. We do not believe that a school that routinely certifies eligibility of borrowers who graduated from foreign high schools can credibly claim to be ignorant of the legitimacy of a third-party verification entity that the school uses for verification purposes. The objection I have here is, well, wait a minute. There's a difference between using a third-party entity that is not credible or that you haven't vetted and an individual at that third-party entity acting rogue and doing something they're not supposed to do. And my point to the department, I wrote a comment, and I'm sure others did too, was, well, look, if you've got a third party that you use, there are a couple or three out there that make a business of verifying foreign credentials, right? And these are reputable companies, and they do this for lots and lots of schools, and they know their business, and I don't think anybody would claim they're not credible. But that still doesn't prevent the possibility of someone getting to a particular individual at one of those entities and getting them to falsely certify to a high school diploma. I appreciate I'm on the margins here, and the likelihood of this happening hopefully is very, very slim. But it still makes me uncomfortable, again, when the department seems to have, it's not just empathy, but not even a recognition of the possibility that a school could be dealing with a third party that would, despite being credible and the school having vetted it, acted in an irresponsible or inappropriate way. And here the department's just saying, we can't even believe that. You would be acting irresponsibly if you dealt with somebody who wasn't trustworthy, right? So it's sort of, they're not even recognizing that possibility, and I think in the real world that's how things work. All right, when would a discharge be based on falsifying a disqualifying condition? So this is one place, and this is probably one of the few places across all four of these sessions where you'll hear me say this, but I think the department's amendment to the existing law here is very good for schools. What I really wanted to highlight for schools, and the reason I brought this up is because I think current law is probably a problem for a lot of schools and maybe something they're not aware of. And I also want to point out that this is one place where even if this rule is completely killed by CRA, current law will still be in place. And you'll still have to pay attention to this particular point I'm about to make. So under the disqualifying condition provision, if a school certify the eligibility of a student who, because of a physical or mental condition, age, criminal record, or other reason accepted by the department, would not meet state requirements for employment in the student's state of residence when the loan was originated, right? In the occupation for which the training program supported by the loan was intended, all right? So the only change here that the department made was they added the word state. In existing law, it just says would not meet the requirements for employment, and they just cleaned that up by saying not meet the state requirements for employment. But the critical point I want to make here is, this is, again, already in the law. You are considered to have falsely certified a loan if you certified the eligibility of a student who, because of one of these issues, physical or mental condition, age, criminal record, or other reason, would not meet state requirements for employment in the occupation for which the training program is being provided. Now, you may say, well, of course, this would be a terrible thing for a school to do, but this gets complicated, right? This gets complicated if you don't know about one of those issues, right? So what must a borrower establish to qualify for this type of discharge? In the Dear Colleague letter that the department issued a while back, and you can see it's there if you want to go Google it, the department clarified that for a borrower to qualify for a false certification discharge under the disqualifying condition provision, the borrower has to provide evidence that they had a disqualifying condition at the time of enrollment and of a state prohibition in that student's state of residence against employment in that occupation based on the borrower's status. So there is somewhat of a level of proof here, and that's good for schools because I think this is really tricky business. What can I do to protect myself against false claims? So for any state in which you have or may have resident students, ensure you know any state requirements for employment that relate to physical or mental condition, age, or criminal record, right? I mean, just right out of the box. And that may seem like a no-brainer, but for schools that have online programs, for example, that prepare people to enter professions, and there are a lot of them out there. I mean, if you offer, a master's in teaching program, master's in education program or something like that, or, alcohol abuse counselor, I mean, there are a lot of professions that are regulated, and many of them may have requirements that relate to physical or mental condition, age, or criminal record. I mean, this could include if you're talking about folks entering medicine or law or other professions as well, for them to be able to sit for the exams and to be employed, it may be that there are requirements that have to be met. And remember, criminal records in here, among others, right? And the problem is, as you all probably know, under the ADA, and I think I have a slide here that I'm probably getting ahead of myself, but, you're prohibited from making certain types of pre-admission inquiries, right? And also there's a great movement afoot to stop asking certainly employees, but even students prior to admission about certain aspects of their criminal record. So what do? You're sort of caught between a rock and a hard place. Well, one thing you can do is the second bullet here. You can disclose any such limitations to prospective students prior to their enrollment. So you're not asking them about their criminal record. You're not asking them about whether they have a physical or mental disability, but they're enrolling in your professional program or your career training program, and you know that to be able to get a job in their state of residence right after graduation, they're going to have to be able to meet certain qualifications. And you can put that in front of them and say, I'm not asking you to tell me, right, but I want you to be aware that if you graduate from this institution and you have one of these issues, you may not be able to get a job in your field, right? So again, this is what I'm talking about. So institutions are prohibited from making pre-admission inquiries regarding disabilities under 34 CFR 10442B2, right? The other thing is you can look at, the department has some guidance they put out earlier this year, just a few months ago, called Beyond the Box, Increasing Access to Higher Education for Justice-Involved Individuals. But really what the department's doing here is they're trying to give you advice about how maybe you can ask less about criminal history while also ascertaining the information you need. The last thing, though, I think you could do, and I've been pondering this quite a bit, is you could consider requiring students to certify that they satisfy all the relevant requirements following admission, but prior to certifying their loan, right? So you are prohibited, again, from making pre-admission inquiries into disabilities, right? And again, there's a public movement afoot, and there are even some municipalities that have gone so far in the employment context to ban questions about criminal history, right? But so you want to be really smart about asking those things, if at all, in and around the admissions process. But what you could do is you could disclose the requirements at the time of admission, and then before you certify the loan, you could have them sign a document saying that they satisfy all of those requirements. And it's hard for me to imagine that the department could object, given that if you certify that loan and one of those things is not true, you are on the hook for a false certification, right? So it would seem reasonable that you would ask for confirmation that those things are true. But again, this is complicated stuff. If you run an online program, I mean, how are you going to know about the physical or mental, potential physical or mental disabilities of an individual that you've never even seen in person, right? I mean, it can be tricky business. So, and again, this is current law. So I want to encourage schools to think about this and financial aid folks to think about this and how they want to try to protect against exposure. Regarding institutional responsibility for identifying disqualifying conditions. So again, this is from the Federal Register. We expect schools to be aware of disqualifying conditions for employment in the fields for which the schools are providing training. Schools that offer career training programs need to be proactive in determining whether borrowers who are training for fields that have such employment restrictions do not have a disqualifying condition for that career. I put this up because I feel like it gives additional support to the notion that you could ask and require someone to certify that they satisfy all of these conditions or don't have the disqualifying conditions prior to certifying the loan. The really critical point here, though, is you can't do it prior to enrollment, right? Or at least not with regard to disabilities. But I think you can do it prior to certifying the loan, and you probably should do it prior to certifying the loan. And the department seems to be suggesting that that's what they expect. Regarding the relationship between disability law and discharge based on disqualifying condition. So the prohibition on pre-admission inquiries regarding disabilities refers to general post-secondary education admission procedures, not eligibility for Title IV student financial assistance. While the discharge laws do not apply to a school's evaluation of whether to admit a student to a particular program, they do apply to its certification of that student's eligibility for Title IV. Therefore, we do not believe that the further limitations suggested by the commenter, someone who raised this issue, is necessary. Again, I put this up because I anticipated some schools would be very uncomfortable about the idea of asking students about disability or other disqualifying conditions prior to certifying a loan. And I believe, based on the commentary that the department has put in the preamble here, that they make it very clear that they not only is that permissible, but it would be expected. They are drawing a clear distinction here between admissions procedures and the certification of the loan, even though I appreciate, as a practical matter, all of this can happen in a matter of days. When would a discharge be based on SAP? So this is the last one. Students cannot file for a discharge based on SAP. So let me just say that again, because that's a really important point. Students cannot file for a discharge, a false certification discharge, based on satisfactory academic progress and whatever the school may have done with regard to SAP. And the department has a lot of commentary that accompanies the reg, but they basically say they think that would be highly problematic because it would be giving students an opportunity to sort of question the decisions the school made with regard to SAP. This form of discharge can only be initiated by the department based on evidence in the department's possession that the school has falsified SAP for students. I think what the department is really getting at here is if they're doing a program review and they determine in the course of that program review, for example, that you've been falsifying SAP for your students, then they also, among their other remedies, have the ability to initiate a false certification discharge process for those students who are affected. So again, this is a tool the department might use in connection with an audit or program review. And then just our TC resources is all that's left. Regucation, you know, we spent a lot of time this year on these webinar series and doing webinars. I think next year you may see more written product from us. We'll still do webinars. I doubt we'll have 3 series, though. So look for the webinars maybe more infrequently, quarterly or so, and we hope to be posting more content actually to our blog in written form. So feel free to check it out. We also circulate our blog posts to our list, so if you don't get those and you would like them, let us know and we'll add you to the list. And that's me. So now we'll sort of talk about questions. Okay, let's see. If a student accepts a discharge, do they relinquish any earned credits? No. Great question, and the answer is no. Now, I've sort of pondered, you know, whether an institution could take the position if there was a discharge and they were forced to pay the department back that the student had not paid the credits and refused to release the transcript. I mean, I think that's a pretty messy and difficult position to take, and certainly from a public public opinion standpoint, I think would be looked upon disfavorably. But it is a really interesting question, right? It is an interesting question. My understanding is that the two are really separate. I mean, you as an institution grant those credits. So if you haven't made any decision to take the credits away or not release the transcript or somehow take some position that the credits are no longer viable, the fact that the feds granted the student a loan discharge has no impact. So I think in a sense, even though you think of them as being related, they are somewhat disassociated. I was pushing this issue during the neg-reg process, keeping a branch open until all time up, but it just seemed to be glanced over during neg-reg and no one really getting how the standard of a process this can be with everyone left completely happy. It will be confusing when two locations in a market are consolidated, close an OPID where you open another branch of a higher quality, regionally accredited branch, et cetera. They made a mess out of this issue. Okay, interesting. Less a question, more comment. But it sounds like what the commenter is saying is they're agreeing and that they were present during neg-reg, and they're saying, yeah, you know, clearly, and I haven't even covered all the possible variations that could involve what the department is considering a closed school. So the commenter here talks about, you know, the fact that you could have a situation where somebody was consolidating two locations in a town. Maybe they bought a bigger, a nicer facility. It's a new facility, and they had two smaller ones. So one of the additional locations goes through a change of location, and the other one just gets closed. But as a practical matter, all the students go to the new site, right? Well, now all those students coming from the one that got closed ostensibly are eligible for a closed school loan discharge. You know, I just think in the real world there are lots and lots of places where there would be dramatic differences in what's actually occurring between a precipitous closure and all these other things. And again, the regulations aren't anywhere near that flexible or discerning. There's sort of a one-size-fits-all approach here, and I think it's going to potentially, if the rule sticks, and even if it doesn't to some extent, because so much of this is in current law, I think it creates an unnecessarily messy or situation where you have sort of collateral damage that's not needed. Or unintended consequences is the phrase I was looking for. Let's see, choosing to teach out, say, 2 out of 15 programs at one location institution would not be a trigger, correct? Well, what's interesting is the department is saying, under the law, an accreditor is required to, any accreditor recognized by the department is required to include in their standards a requirement that you provide a teach-out plan. I think it would only become an issue at the program level. I don't think it's an issue if you're just teaching out 1 or 2 programs. The only way it becomes an issue at the program level is if a state withdraws your authorization to offer a program, right? So that's a more extreme situation, right? You still certainly have the flexibility to retire or sunset a program or 2, but it does become problematic if it's the first one. If the institution's state licensing or authorizing agency revokes your license to provide a single program. So in that case, you could have a situation where you have a location that offers multiple programs. If the state revokes your authorization to offer just one of those programs, then you still have theoretically an obligation, because now you have to provide a teach-out plan to your accreditor, again, presumably for that one program. But now you also, it triggers this obligation to provide students with a closed school loan discharge application, despite the fact that, from what I can tell, they would not be eligible for a closed school loan discharge under the law. Let's see. We have locations for flight training programs that are not included on our e-card due to not meeting the additional location regulations. If we decide to close one of those locations, is this subject to the CSD regulation or not, because we do not include them on our e-card? That is a great question, and I believe the answer is no, they would not be, right? If a location is not on your e-card, then that means you're not offering over 50% of a single program at that location. And from the department's view, and your accreditor may take a different view, but from the department's view, what that means is it's really not a separate location. It is part of your main location, right? And more to the point, it's somewhat invisible to them. You would have no obligation to take that additional location off of your e-card. The department would not be aware. I'm not suggesting, trying to pull a fast one. I'm just saying it really is invisible to them. It's like that location doesn't exist almost. But again, what you're telling me is it's not on your e-card, which tells me that you don't offer more than 50% of a program at that site, which is why it essentially falls under the radar here. No pun intended. is there a good calendar to use to determine legislative days versus calendar days? Could we use the congressional calendar that you sent out last week to see the days Congress is in session, or is there a better resource? I'm not sure what congressional calendar I sent out last week, but I can tell you two things. So I don't know exactly where you could find something nice. Oh, maybe that was I apologize. It may have been that our lobbying group or a different component of the firm sent out the congressional calendar. I didn't personally, so that may be true. The thing is, though, this is a little bit of a moving target because you count the 60 days back. The 60 legislative days that you count backward is impacted by when Congress officially ends its current session. So, like when the Congressional Review Service ballparked May 30, they were ballparking when they expect Congress to conclude its current session. And I know that Speaker Ryan is very aware of this issue and the timing, and so is thinking very strongly about when to conclude and maybe speeding that process up. But my understanding is how you count the days, when you start counting the days back, and how many days they will have in the next session is impacted by exactly when the current session ends. So I apologize, I don't have a better place for you to get the legislative days. If you want to email me on the side, I can try to find something. But the other important point is, even if you had a calendar right now, you would not be able to count back conclusively because I don't believe the current session of Congress is ended, unless I just missed that. Apologize if I did. If you can't ask about a criminal history, but the school advises them that they won't be able to get a job if they have a criminal history, a student can still enroll, but then won't be able to get a job. But that student will ding us with GE since they will have a student loan they can't repay because they can't get a job. How do we deal with these situations with respect to GE? You know, I think maybe the way to use that is the disqualifying condition piece, right? I mean, if a criminal history is actually a disqualifying condition, meaning they cannot get employed in the industry, and I don't mean wouldn't be favored. Let's talk about that second. But for starters, let's say this person cannot get a job, so like pharmaceutical technicians, and you know, I know there are several places where if you've got a felony or something like that, you just can't get certified to practice in the state in that profession. If that's the case, then what you can do is, by the way, I also am not aware of, generally speaking, of a federal prohibition on you asking about their criminal history prior to enrollment. In fact, my understanding is the vast majority of schools, at least at present, and there was a study done on this not too long ago, and I don't mean for-profit schools, I mean schools. The vast majority of post-secondary institutions do still ask about criminal history. I think the department is trying to get people to ask more specifically about felonies and not to just ask broad open-ended questions. You know, if to be a farm tech in the state you can't have a felony, then the department says then you should ask if they have a felony, not if they have any kind of criminal conviction, because that could rope in misdemeanors and such and result in unwanted discrimination and things of that nature, right? So right now I think you can, though, unless your municipality or state has some sort of prohibition. You know, at the federal level, the Department of Education does not ban criminal history as an inquiry, as a pre-admission inquiry, right? Okay. They are trying to encourage people to go about it in a certain way. But let's say that changed, or you are in some place where you are prohibited for some reason under a municipal code or something from asking about criminal history at all of a student prior to their admission. Well, what you can do or could do, and I think appropriately, and I think this is what the department was saying, is you could still refuse to certify their loan if they won't attest to the fact that they do not have a criminal history, so that you won't be on the hook for a false certification discharge, right? And if you are requiring students to certify that they have no felony or whatever that disqualifying condition is prior to certifying the loan, and they refuse to do that, well, now that they're not going to have loans to get through the program. So you've probably eliminated them from the program, right? So that's one way potentially to deal with it as well. Let's see. Does not taking enrollments automatically mean closing? Suppose you were ceasing enrollments pending major new programs, accreditation change, or capital raise. Yeah, that's a great question. I've actually had this conversation with clients in recent months as well. No, I think I will tell you as a practical matter, if you cease new enrollments, there are going to be people who are going to ask questions, certainly, your admission staff among them. And you may get calls from your accreditor or others. If you have partnerships with other schools that occasionally send students to you, either because they take your graduates or you know, you have a program that their graduates can go into, I mean, they can ask questions. So, you know, you're going to have a lot of people, if you cease enrollments, that think it is tantamount to closing and at least raise the question. But certainly you or your board, more appropriately, could say, you know, we are voting to put the school on some sort of probationary or observational status, and we're not going to take any new enrollments until that status is completed and we've concluded our review or the school's concluded its review, without taking any step or, you know, mentioning any intention to close. Right? You could even in that process say we're also at this point going to develop a contingency plan in the event that we did decide to close. But that's still distinct from, you know, your board determining to proceed to closure and or actually voting, you know, the school's closure, which is typically the very last event that occurs after everybody's gone. So, yeah, it's a great question. And I don't think that taking enrollments, ceasing to enroll students is tantamount to closure. They're not the same thing. But again, optically and practically be aware that if you cease new enrollments, certainly questions are going to be raised. Could you discuss going after school affiliates and principals? Yeah, well, to be clear, I mean, what the department, what the Congress has authorized the department to do, and in fact directed the department to do under the HEA, is if amounts are discharged pursuant to a closed school loan discharge, Congress has directed the department to pursue those amounts, recovery of those amounts against the school, its affiliates, and its principals. And that is in statute, right? So in theory, if the department went after the school and was unable to recover against the school, there would appear to be statutory authorization for the department to try to pursue the recovery of those amounts against principals and affiliates. And I get that that's a really important question for a lot of people who may be on the phone and or their board members and their company's principals and affiliates. Unfortunately, the fact is that there is no spot-on definition of principals and affiliates in the law, and the department's practice on this point historically has varied. Right? I mean, it is at least my experience and understanding that the department does not always attempt to go after principals and affiliates if it attempts to go after a school, right? But the salient point here is that that language is in the statute, and there is absolutely exposure, I believe. And, you know, it's one of those questions of how aggressive the department wants to be. Does state authorization agency include a professional board that also must approve a program, like the Board of Nursing? So would it be a trigger if a Board of Nursing revokes approval? Yeah, potentially. You know, I haven't researched that specifically, but I would expect the department might take that view. I don't know that state authorizing agency is limited to the entity that authorizes the entire institution. Also, you know, there can be situations in some states where, for example, you would have a state authorizing entity that would authorize your entire institution but not authorize a certain program. For example, if your state authorizing entity that authorizes you to operate, or, you know, your charter, if approval of nursing programs is entirely carved out from that entity's authority, then it's not like you've got double approval for the nursing program. It is the case that the nursing board is the only entity that authorizes that program under state law. So in that case, I think it would increase the likelihood that it would be viewed as a state authorizing entity. That's getting a little into the weeds, but the point is I think it can depend a little bit on state law and how it works in your particular circumstance, and also I think there's probably some room for interpretation on that point. Thanks to everyone again for tuning in on this one. I think this is a really interesting and important topic, and I know that it doesn't always immediately resonate with everyone. Have a great day and talk to you soon.